Before this murder trial even begins, the courtroom takes an unexpected turn. A surprising discovery, critical legal motions, and a judge making key rulings could shape everything the jury is about to hear. Stay until the end to see how these pretrial decisions may influence the entire case.
That's a different count.
Right, there's 3 or 4 counts on it.
All right. Could I see the indictment on this case, please?
I did try to fix it on honestly on my side.
Mm-hmm.
So I don't know why
It happens.
and there's a lot farther here.
Oh, no problem. See, you're better than I am because it takes me a long time to try to find it on Odyssey. You know, whoever made Odyssey, if you type someone's name or number in, to me, there should be a search engine where you just say indictment, and then there it is.
Oh, there is.
Oh,
On Odyssey.
what?
There's a way to like look up like.
Get out of town. And I just put in the words indictment and it pops up.
That's like figure it out.
Oh, wow. See, you are not living unless you learn something new every day. I just learned we can do that. All right. We're going to go on the record in 2023 CR 4371B, State versus Marco Antonio Marino Vasquez. We have an interpreter here. If you can raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Arlene Abrams, license number 2081.
All right, and then for the state
Megan Galloway for the state.
and for the defense.
David A. Garcia, attorney for Marco Moreno Vasquez.
All right, and we have an interpreter in training. If you'll state your name for the record. All right, thank you. All right, both parties have agreed to start jury selection tomorrow morning. Is that correct?
That's correct.
That's correct, Judge.
And then that'll give you a chance to maybe get different clothing if you want to. The jurors will be up here. I've asked them to be up here first thing in the morning. They probably won't arrive till 10. So I'm going to ask that everyone be here no later than 10 a.m.
Yes, sir.
All right. And then the court has received an acknowledgement of discovery. Counsel, have you received all discovery and reviewed it with your client?
I have, Judge.
The court will find that the state is in compliance with discovery. And then defense, it's the court's understanding that you have motions.
We do, Judge. There's about 9 from the defense and several from the state. And the prosecutor and I went through them this morning so that we can sort of make it easier and just put on the record what we're all agreed on. So motion for discovery, we're agreed and everything's been turned over. There's an order in the back.
All right, the court then is signing the order on the motion for discovery, and for the record, the court will note that the defense has stated they've received all that's been requested in the motion for discovery.
Judge, the next one's motion for discovery of punishment evidence. The state agrees to that, and they've previously emailed me one. They're going to be handing me one today, which I'm in receipt of.
All right. For the record, the court will note that defense has stated that he has received discovery for any punishment evidence. And the court is signing the motion that it is agreed to.
The next motion, Judge, is motion to require state to reveal agreements. There is a co-defendant who previously pled. The state and I went over it. They are agreeing to this motion and telling me that there are no agreements regarding any witnesses in this case against Marco Moreno.
All right. My pen just died. All right. For the record, the court will note that the state has informed defense counsel that there are no agreements that have been reached between the co-defendant and the state, and the court is signing the order that if something changes with that, state let defense know.
The only thing that is So just so the record is clear, there is no agreement that the co-defendant had previously entered into a plea before the court. And so I am going to tender a copy of the admonishment and stipulation to the council.
So received. Judge, the next motion is a motion for witness list, which is agreed to, and the state has previously provided me one, but they're going to provide me another one this morning
All right.
or this
Then-
afternoon.
Thank you. And the court will sign the agreed motion for the state to tender a witness list.
I've received that, Judge. The next one is a motion for discovery of exculpatory and mitigating evidence, basically 404B, which they're agreed to, and it's a continuous duty that they understand.
All right, the court will sign the order and note for the record that the state is in agreement and the state is in compliance with any exculpatory and mitigating evidence.
The next one is motion to suppress, Judge. Statements, which we're going to run with the trial because there is a statement to the police that my client gave when he was arrested, which they've transcribed. So that's agreed to, and we're running the motion to suppress any statements with the trial.
All right, so the statement is in Spanish.
Yes, Judge, and it has been transcribed by the certified translators here on the floor at a trial of the notice in advance of 45 days prior to the trial. And so the state plans to approach the court prior to calling the witness that we would proffer the exhibit through to have a hearing outside the presence of the jury on 3822, and I can also provide you the copy of the transcription.
Yes, if I could have a copy of the transcription, because of course I don't know what's in the transcription, and I don't know if there are certain things that the state has agreed would not be placed before the jury. So we'll just.
And I'll
have to
go
see.
through that tonight, and we'll discuss it tomorrow morning before they proffer it.
All right. So let me let you keep that
Okay.
because it tends to get lost.
All right. The next one is a 404B notice, defendant's request for notice of state's intention to use evidence of extraneous offense at trial. And they will approach, it's agreed to, but they will approach if they intend to use anything in their case in chief.
Yes, Judge, so the notice that I filed encompassed any evidence that I would intend to use in case in chief and in punishment regarding impeaching the defendant or any prior conviction where I am in agreement to approaching the court before getting into any of that.
Okay.
Thank you. Next is the motion to suppress, Judge. They're not intending to induce anything other than statement, to my knowledge, but that could change. And so if it does, they're agreeing to come before you before any evidence is proffered to the
I'll
jury.
let you hold on
Hold
to
on to
that.
that.
Yes.
And then last, Judge, is a motion in limine. And so that's regarding any prior convictions. Included in that is the fact that there's an immigration hold against him. There's also an issue regarding how the police got to him. It's my understanding that at the crime scene where the murder took place, they were able to look at video and get the license plate of a vehicle. They tracked that vehicle down to the registered owner, who's not my client, and they spoke to him. And in that, he was telling the police something to the effect that he reported the car stolen, that he had contracted with my client to purchase it, to sell it to my client. But at some point, funds were not remitted to this alleged owner. And so he reported it stolen. I've talked to the state about it. I believe they're in agreement that they're not going to introduce that.
Yeah, Judge, so I believe the issue regarding payment possibly could be broached in punishment, but the intention of the witness is just to get the agreement and the circumstances of how the defendant ended up with the motor vehicle and guilt.
So we discussed that if they do bring that witness, he needs to be prepared to talk about he sold the car to my client and not go any further regarding an alleged
F. Okay. Well, I will tell you, both parties just need to approach and state, just let your witness know.
Yes, Judge.
And I believe that that covers all of our motions, Judge.
All right. And state you have motions?
A motion at verbally, I'll get it printed for the court, but it's just regarding any wrongs, bad acts, or crimes of the named complainant and the indictment, Danielle Fernandez Valadares, or any other witness that is called by the state, as well as any information to remember to defense under 3914 regarding prior disciplinary actions of any officers in their expectation. And it's just that he agrees to approach before he.
So what I'm asking is after they finish with their directive, their witness, that they proffer me the NCIC, TCIC, so that I can look at any convictions or
Yes.
bad acts, and then we'll approach and discuss what I can get into.
Yes. All right. Just approach. And if someone feels like, oh, should I approach on this? Just approach. All right. Anything
I
else?
think that covers everything.
All right. And has your client done an election of punishment?
He has not, Judge. I was going to talk to him about it, and we'll do that tomorrow.
Well, if we could get it done today.
Okay.
So we'll do the sign in an election of punishment. The court has not made a decision on your case, but everyone who's up for trial, they have to make a decision on if they were found guilty, if they would go to me for punishment or go to the jury for punishment.
So we'll discuss that. We can make a decision. The one other thing, Judge, is since we're going to have one or two interpreters here, because I understand some of the witnesses speak only Spanish, that the state's bringing, in voir dire, when we speak to the jurors, I'm sure a huge percentage speak Spanish. So do we want to instruct them that they're not to interpret it
They
themselves?
always do that.
Let
Yes.
the interpreter make the interpretation.
Yes.
Okay. I think that, because I was going to touch on that, but I didn't want to step on your toe.
Oh, no. I always tell the jurors that whether they speak a language or not, that the interpreter is the official interpreter. And if they think the interpretation is correct, great. If they think it's incorrect, doesn't matter. They go with what the interpreter is stating.
Perfect.
Okay, sure.
All right. Thank you, Judge.
Okay, thank
We'll
you.
make that decision and then I'll see you in the morning.
All right, thank you.
Thank you.
You're welcome. Oh, Donata. Now, see, Deputy Laura, they haven't done very well with me by Spanish. That's on them. It's the teacher, not the student. But I do know thank you is not Spanish.
She's not a very good student.
They
Now it's your turn. Do you think these pretrial rulings gave both sides a fair chance, or could they change the outcome before the first witness even testifies? Share your opinion in the comments below. If you enjoy real courtroom proceedings, legal analysis, and the most compelling trial moments, make sure to subscribe and turn on notifications so you never miss the next courtroom drama.